Good evening. Captain Retired Matt Edwards here with the next installment of the Observation Post weekly Facebook Live broadcast. Now, I'm going to continue on with my last point, or from my last point. Number 254 in the numbered list that I have posted in my files section. A pension contribution might be seen as a loan of sorts because the employer defers payment for services rendered in the present until the future. Now, earlier I was going through some of my old posts. I was looking up stuff because that's how I created Observation Post. It was for a searchable database. So, give me a second. I was trying to remember what the name of the case was, which listed some of the benefits to the employer because pensions are primarily supposed to be for the pensioner, the employee. Anyway, it was Nolan, Supreme Court of Canada, 2009. Paragraph 53. Nor can the term exclusive benefit be construed to mean that no one but the employees can benefit from the use of trust funds. Many persons will benefit indirectly from the use of pension funds. Notably, the employee's family would benefit from the employee's long-term financial security. Peace of mind. Paragraph 54. An employer might also benefit in a number of ways. The U.S. Supreme Court, in dealing with an employer's introduction of an early retirement plan, recognized that an employer can legitimately receive a number of incidental benefits from a pension plan, even though the plan is subject to legislation containing exclusive benefit language. These incidental benefits include attracting and retaining employees. Now that was given by the Roy Federal Court of Appeal 2003 case. That was what they said the purpose of the Canadian Forces Superannuation Act pension was for. It was partly a deferred salary and partly to attract and retain Canadian Forces members. The second one, paying deferred compensation. Okay, here's the deal. When you serve an employer and you have a pension, they could pay you some now for your services rendered, and they can put off some for the future. Now that means they saved in their current payroll costs, and they put that cost on into the future. No one can say that's not a benefit that the employer gets. Whether it's the main purpose of a pension or it's a incidental benefit that the employer gets, but it is definitely a benefit. Settling or avoiding strikes is another reason. Now, my wife just came off the picket line. Part of it caused a bit of a fuss with me, actually, because she said the time that they served on the picket line will be counted as pensionable service. Now, knowing a bit about pensions, like I, consider myself a subject matter expert in this field, that set me off. I said you shouldn't have to pay anything for a pension contribution. Your service should be enough. The employer wants both the employee and employer share normally when a person isn't at work, and they're going to say the person's going to get to keep the time. I was on leave without pay, and after I came back, well, I couldn't come back after they made me retire medically from the public service. I bought back 3 years of service, and I had to pay both the employer and the employee share of the contribution. If you're working, you would have only had to pay the employee share. But as I keep saying, what the government is saying, or any employer that has a contributory pension instead of a non-contributory pension, they're saying that you're getting paid too much. When you had to pay for your own pension and you have a single employer pension, you're paying for nothing. Now, on the other hand, it actually gives the pensioner a better argument that they own the pension because they put money into it themselves. So as much as I say they shouldn't have to do it, because it is set up this way, they can't say that it's not your property. Okay. providing increased compensation without increasing wages, increasing employee turnover, because if they didn't have a pension, people would work till they died, and then the next generation of people wouldn't be able to get a job. So by having a pension available, it encourages employee turnover. And reducing the likelihood of lawsuits by encouraging employees who would otherwise have been laid off to depart voluntarily. I don't get that one, because if they get let go legitimately without any wrongdoing, then there wouldn't have been any damages, any lawsuits. Anyway, the paragraph continues. Such indirect or incidental benefits from the use of pension funds do not mean that the funds are being used for a purpose other than the exclusive benefit of the trust beneficiaries. Notice the word trust. Pensions are always trust funds. The government can claim that the Canadian Forces, RCMP, and public service pensions are not trust funds. They'd be wrong, because all pensions are trust funds, because you put money belonging to somebody else into the bank and you leave it there until they retire. Hope I'm not being too sarcastic, but anybody who says that the government doesn't owe a fiduciary duty because it holds on to trust funds is crazy. Now, I say the Canada Pension Plan operates on the same principles because it's a pension. Now, it's a multi-employer contributory pension, and unlike what I was saying about a single employer pension, that's the only way the Canada Pension Plan could work. Because you have different employers, you can't operate where the employer only makes the payment. But on the other hand, the payment made by the employer is made on behalf of the employee. Okay? So if you're a self-employed person and you want to get a Canada Pension Plan, you have to pay both shares, the employer and the employee share, and you don't get a bigger pension because you paid twice as much. See? Anyway, I'll reduce this now because I think I made my points. I was trying to remember which case it was. I thought it was Monsanto, Supreme Court of Canada. I thought it might have been Bashul, Supreme Court of Canada. But lo and behold, it was Nolan. Point number 255. The old citizen gets a $78,000 income exemption before a clawback under the Old Age Security Act. But older disabled veterans only get forget the older part. But disabled veterans only get $20,000 exemption from clawback. Why? See, I asked this question at a town hall to the deputy minister and the minister of Veterans Affairs, and they said they called around all the different provinces and they found out which one had the biggest exemption, and then they went with whichever province had the biggest exemption. It was $20,000. Now, I was thinking later, I didn't think of it at the time, or I would have asked them, how come they didn't use the $78,000 in the federal old age security system? How come Canada values older people who are retired more than disabled veterans who are retired and cannot work? Now, don't get me wrong. All of the money that's being paid, there shouldn't be any clawbacks. There shouldn't be any income testing. But as a backup position, as a fallback position, if, some of the things I'm saying never gets fixed, why didn't they use a similar program? If you're going to do it, give you the benefit of, the better, exemption. I think I make a good point. And I think, why didn't they think of this? Now, 256. Conflict of interest with a forced Canada Pension Plan disability application when the employer is also the underwriter / insurer. Now here's the deal, what happened with me. I became basically too sick to work in 2009. Then I went off and got Sun Life Insurance, which is the Treasury Board Secretariat insurance, in, say, August of 2009. Now, after 3 years of being on that insurance, the government said, you had to take a medical retirement, and then, they discriminated against me because they're disabled. You're not supposed to, treat people differently because they're disabled. They could have adapted my chores, my duties, or something. However, I didn't have any union backing, so they kicked me out. Now, at the time of my getting booted off of the books at Canada Revenue Agency, Sun Life comes to me and they say, we think that you qualify for the Canada Pension Plan Disability. Now, what they're saying is they want to lower their payment because they reduce the amount. And they say, if you don't apply when we ask you or force you to, then we're going to estimate the amount of the Canada Pension Plan Disability at the maximum and reduce your long-term disability payment accordingly. Now, so if you apply and get it, then you're no further behind. But if you don't apply and they reduce it, you are getting punished by this estimation. So the point of this numbered issue is that if Sun Life was operating on behalf of Sun Life, that's one thing. But if they are merely the agent for the government of Canada, in my case, Canada Revenue Agency, then they're in a huge conflict of interest. Because it's not a three-party system where there's me, Sun Life, and Canada Revenue Agency. There's me, and there's a gang of two. In legal terms, it's called an agent and a principal. So the principal is Canada Revenue Agency, the agent is Sun Life, and they operate together to form one party. So you have a dispute where you have one against the other person, and they're going to take their side, and I'm going to take my side. And it's not like an independent party could say, well, this is the way we see it, and we have no stake in the game. See? So one of these days, I predict this is going to bite them on the ass. Because you're not supposed to have such a system where you make it appear fair-ish by having three different parties. But in reality, there's only two parties. And each one's going to take their own position, their own side. Anyway, next point. 257. Parry versus Cleaver. That's a 1969 British decision. And Income Tax Act Section 61F. The government ignores the common law. Ignorance of the law is no defense. Now, what I'm talking about is what I was saying before about the pension contribution the government makes, or any employer makes. And if you get a payment from the employer made for anything, it's basically for your services. It's salary. They can call it a pension contribution. They can call it a CPP contribution. They can call it an employment insurance contribution. They can call the Canadian Forces Superannuation Act contribution. But it's simply pay for your services. Now, the point about Income Tax Act Section 61F is that the government has a policy that if you pay all of your insurance premium by yourself and the employer does not contribute anything, if you become disabled, you get a long-term disability that is tax-free. So the Parry versus Cleaver case, it was about damages, and the person was getting a pension that they didn't contribute to. So they paid no money into the pension. The employer paid it all. So the people having to pay the damages thought that was an important enough distinction that they could ask the judge if they could claw back the value of the disability pension from their damages because the employee didn't contribute to it. So the judge said, go to hell. The working man's service has value. And why should he be treated differently than if he had to pay cash for it instead of service? Why should he suffer because of that artificial distinction? So if you put that in terms of the Income Tax Act and say the Service Income Support Insurance Plan or the Sun Life policy or the Great West Life policy or the Industrial Alliance policy for members of Parliament and managers, the government says it pays 85%, but it was earned in service. So the employee has 15% deducted from pay, and 85%, instead of being paid to them, gets paid to an insurance company on their behalf. Now, if the person becomes disabled, you have to pay them tax-free long-term disability. And I think this is an artificial distinction anyway. I refer to the Altman Ontario Court of Appeal 2011 case. The case wasn't about taxes, but the judge did mention during the case that both the employer and the employee contributed towards the premiums. And Ms. Altman received tax-free long-term disability. Now, on paper, according to the Income Tax Act, she has to pay taxes. Why did she get tax-free payments? This is one of my theories, is that the person making the payment, the insurance company or the administrator or whatever, it's up to them. If they don't send in a T4A to CRA and a T4A to the person, then there's not going to be any taxes. But if they choose to read things a certain way, and the government insurances are going to read it the way that gives them the most taxes, then they will send a T4A or whatever tax information slip they decide to provide. Now, the problem with that I have is that, well, they're being dishonest. First of all, they send in a T4A. In my case, they had Manulife on one for 2013 to 2017. And they had Sun Life on the other one from 2009 to now. But those parties didn't pay me anything. I got insurance payments from the Government of Canada, where I had bought insurance plans from the Government of Canada, and these alleged insurance companies are not insuring anything. If they had been, then Dennis Manouche would have had to sue Manulife. And Gerard Butte would have had to sue the Great West Life policy company for the RCMP. Now, in both cases, it was the Government of Canada, or Her Majesty the Queen at the time, now it's probably His Majesty the King, but in both cases, the taxpayer had to pay damages to the people they hurt by taking the Pension Act pension into account, because they used an indemnity payment for your injury in military service to reduce a non-indemnity payment paid in contract as if nothing was wrong. When, if you had gone to court and you were being paid damages and you were getting a long-term disability policy, which is non-indemnity, so you get indemnified by the damages, and you're entitled to your non-indemnity and contributory insurance in addition. Now, it almost looks like you're getting two forms of compensation, but you're not getting an indemnity and an indemnity, which would be double indemnity. You're getting an indemnity and a non-indemnity. See? So as long as one of the payments is non-indemnity, you can receive both. They're not related. See? Anyway, I'll probably stop there because I was going to do something a bit different tonight. I'm trying to get back on the horse a bit, so I called my member of Parliament staff, and I ended up speaking to them for about an hour, I think. And I was a new person, so I had to go over a lot of stuff. And I also called the Office of Veterans Ombudsman because I figure what the plan is to get both the Member of Parliament and the Office of the Veterans Ombudsman to support my request for my injury in military service. And as I said to both parties, I said, listen, you can't have someone change their mind, okay? So CPPD, D&D Manulife, they said I was hurting service because they said, first of all, I couldn't get my insurance. When I said to them that I had to get it because I was medical released, okay, before 1999, CPPD wasn't automatic. Everybody had to apply. But after 1999, they said it was going to be automatic on medical release. Now, a 2003 report put out by Treasury Board about total compensation, they said that before 1999, it was a terrible sin. The government were medically releasing Canadian Forces members who then they had lost their career, but they didn't get the insurance that their premiums had paid for. Now, instead of looking at this, and the problem was the definition, they said, that they used the any occupation definition instead of the own occupation, when the own occupation is the definition used by the Treasury Board policies for the first 24 months. So after they fixed that, they didn't go back and fix it and make it right for all the people that got medical release before 1999, which I say is a wrongdoing. But it seems like to make their amends, they made no more application and you might get denied. So medical release, automatic CPPD, except for reservists. So reservists weren't even in the CPPD policy until 1990. And then in 1990, they made it as an optional plan. You could buy it or not. But in 1999, the government decided to make it mandatory. So everybody got it. But they put into the policy that you had to be injured in service or you didn't get your long-term disability. Now, I say this is a wrongdoing. It's terrible. It's bad. But the fact that they accepted my claim means the government of Canada admitted I was hurt in service, because otherwise they wouldn't have paid my long-term disability between 2013 and 2017. And when I went to VAC about this, when I was trying to get my earnings loss benefit fixed up, my rehabilitation bullshit, they seemed to buy into this for a while. They said they'd check it out because it made sense to them. If you're accepted by D&D, why should VAC have to reinvent the wheel? But they didn't. But I got to back up the train a bit. So back in 2012, when I was fighting with CPPD to try to get my automatic on medical release CPPD, I didn't get it, and 9 months later I said, well, I'm going to go check VAC out. So I goes down to VAC, I talks to him, and I says, listen, CPPD Manulife's not doing that for me. What are you guys going to do? Here I am 9 months out of the military, and I'm not getting a cent from nobody. So they put me into the rehabilitation program. Now, because they have to have a justification, they put into the list of reasons under Rehabilitation Record of Decision, the RROD, 5 medical conditions caused by my service, they said. Now, in the documentation, I didn't have it at the time, but since then I've been researching. The RROD is a very important document because it certifies you as being hurt in service. It says it's the department's position, not the case manager's opinion. And that, because it's such an important document, they can't change it later. So if that's the case, how come they kicked me off of rehabilitation in 2013? So this is why I reapplied and why it came up about the injured in service on CPPD should be the same as VAC. But you see where I'm going with this? I want to get the Office of the Veterans Ombudsman and my Member of Parliament to support this because it's stupid. This is absolutely absurd what they're doing. It reminds me of what CPPD did at first. They didn't want to pay so bad. The first thing they said to me was, besides the fact they said you got to be hurt in service, they said, you told us you're getting Sun Life from your work with CRA. Well, our insurance is 75% of $2,700, a deemed amount, which is $2,025 a month. Now, you told us you're getting $3,300 a month from Sun Life. So because of the clawbacks that we have in our contract, in our policy, then you won't get anything even if you apply and get approved. And I said, are you fucking nuts? I said, if you I had two policies at two different positions. Your insurance policy doesn't cover my civilian salary. My civilian insurance policy doesn't cover my military salary. So neither covers both. And I said, if you have this position that the Sun Life has to be taken into account, then you take Sun Life into account. Sun Life might have the same position and they take you into account. And despite having two insurances, I would end up getting nothing because you claw back them and they claw back you. I said, have you been told to go fuck yourself, you son of a bitch? No, never got me nowhere, obviously. Because no matter what they do, they think they can get away with everything. Now, that particular sort of story ended up, I don't like to take no for an answer when I'm right. So I ended up contacting manager after manager until I got to the Minister of National Defense, Peter MacKay, and they decided that whoever started paying me first would be considered a first payer, and therefore, Sun Life was the first payer, and therefore Manulife started paying me, and I think they thought I'd tell Sun Life, and then Sun Life would deduct Manulife, when I know that these are both non-indemnity and contributory insurances, and both of them cover different salaries, and I didn't fucking tell Sun Life because it's none of their goddamn business. Now, but as a follow-up, after all of this shit hit the fan in 2015, when Manulife called me up one time and said, apply for the Canada Pension Plan. Now, I had gotten approved about a year before, but they were already deducting it at Sun Life, so I figured it was none of Manulife's business. So I neglected to tell them. Why should I tell them about something? Well, another insurance company's already deducting it. Finally, I got fed up with this bastard bugging me. I said, listen here, buddy. I said, I already applied and got approved, and Sun Life was the early bird getting the worm, and they're deducting it from my insurance. So you can go to hell, okay? I've already applied for and gotten it, and you're telling me to apply for and get it so you can save? Well, I've already done it, and some other insurance company saved. Now, their response to that is they started to take it into account as well. So Manulife decided to take it into account despite the fact that they knew Sun Life was doing it. And then my pension was taken into account. Both pensions were taking my Canada Pension Plan into account. The public service pension went down $500 a month. My Canadian Forces Reserve Force pension plan went down by $50 a month. So I got about $1,000 Canada Pension Plan. I lost $1,000 off of Manulife, $1,000 off of Sun Life, $500 off my public service pension, and $50 off of my fucking Reserve Force pension plan. Now, in what world is it okay to give a person $1,000 and then take back $2,550? No, it's $1,550 less than if I had left it alone. Like, these assholes, all I can call them is assholes. All they care about is saving a buck for themselves. They're not looking at the moral conundrum. This is a person hurt in service. Okay, remember, it says something that Section 41A3. So they should ask that for themselves, should we do this to a disabled in service veteran? Should we put them through this agony of having to apply for the Canada Pension Plan, even though, they might get denied? It only has a 35 to 40% chance of approval. The Canada Pension Plan disability has an appalling approval rate. Okay? So they make you apply for something under threat of estimation, and then they ask for the money to get sent directly to the company. Now, here's the problem with that. Here's one or two of the problems with that. They put a false name on the irrevocable consent form that is created by Service Canada. Instead of saying the Government of Canada as the underwriter / insurer, they put the name of Manulife or Sun Life or Great West Life or Industrial Alliance on it. Now, someone might say, well, what's the big deal? Well, it's forgery. You're putting a false information on an official government document. And the purpose of that document is that Service Canada will redirect the payment, and instead of the payment coming to the pensioner, the payment gets sent directly to the insurance people. Now, here's the insult to injury thing. The person who gets the money isn't the disabled person, but they get a bill from the pension people for what's called bridging. In my case, I got $9,800 bill from the Public Service Superannuation Act, and I got a $909 bill from the Reserve Force Pension Plan. So, had I signed that irrevocable consent form, I didn't, and the money came directly to me. But if a person signs the irrevocable consent form, the money will be sent to an insurance company. But they get a bill from the government, from the Public Service, RCMP, or the Canadian Forces Superannuation Act people, as if they got the money. Now, you can't say you got, say in my case, $15,000. And therefore you owe us this much money because there was an overlap in the payments, and, therefore you owe us money. Now, if the money don't come to you and get sent to Manulife or Sun Life, you can't claim that the person owes you money, because they didn't get the money you said was the basis of your claim. It's common sense. So the government's one of these days going to have to pay up all that money they collected in bridging. They're going to have to pay a lot of that back. Not all of it, because there's people like me that refuse to sign the form. But many people will sign the form, and the money will get sent to somebody other than the pensioner. Now, it gets worse. Service Canada sends out a T4AP in the first year, despite the money having gone to Manulife, Sun Life, or Great West Life, or Industrial Alliance. They send a tax form, a T4AP form, to the disabled pensioner. So they pay taxes on money they didn't get to receive or enjoy. Now, it is a basic principle of Canadian taxation that you have to receive the money that you're getting taxed on. If you don't get the money, you cannot legally be required to pay taxes. You want to tax someone? Tax Manulife, tax Sun Life, tax anybody else that might have gotten the money, but you can't tax the person who didn't fucking get it. Tell me you understand that. Now, how this shit hasn't hit the fan and all this stuff, I don't know. I've been squawking about it enough, hoping other people would squawk about it, and then eventually the shit would hit the fan. But so far, it hasn't. I'll point this out, even though I probably got it there for a future point. In fact, just for badness, I came up with an argument to the government to make them end clawbacks. I was going to say to them, you know how much taxes you're losing on this? If I got this extra payment, my insurance, in addition to my Canada pension plan, I would have higher income, and therefore I would have to pay more taxes. But because you claw back, not you, but the insurance companies claw back, say $12,000 a year, $1,000 a month times 12 months is $12,000 a year. Therefore, the government loses the taxes on that $12,000. Now, that's only the case of Captain Retired Matt Edwards. Now, multiply that about all the people that got long-term disability and get Canada Pension Plan disability across Canada. I think there's a pretty big tax hit the government will get, based on this. Now, don't get me wrong. If they're half smart, they'll say, well, we save more on the clawbacks than we do on taxes. Now, that might apply only when the government is both the insurer and the tax person. But imagine all the companies that are private employers. They're not tax collectors, so they don't care about taxes. They are the ones saving with the clawbacks, and the taxpayers are the ones paying higher taxes because of it. So, even though I'm saying it shouldn't be taxed in the first place, we can use that against them in the short term by saying, how much of it, remember I keep telling, at least if you remember, there's a thing that called the Finance Canada Tax Expenditure Reports. And what it is they list off in an annual report all of the foregone taxes that they could have collected, but they didn't because of public policy. So they might put the Pension Act there and say that, we paid this much out in pensions, but because we made it tax-free, we're losing this much money in taxes. And they call that a tax expenditure. All the years that I've been looking at this stuff, I've never seen a tax expenditure listed for long-term disability insurance clawbacks and Income Tax Act Section 61F, because they must not have thought about it. But I think we might be able to work that in and try to make the government think they're going to get more taxes to stop clawbacks. But besides the point, it's just flat out illegal. The government said so, the provinces said so. In the provinces, they have set up insurance is exempt from creditors laws. And that's because insurance is designed for a fallback position if you need it in times of peril. So because of that, the insurance laws in the provinces say that you can't go get a judgment against someone, serve the judgment to the insurance company, and the insurance company divert the payment to them to satisfy the debt. You can't do it. It's illegal under provincial law. Now, that's a very important point. I'll end on this note, but the Service Income Support Insurance Plan is allegedly insurance. It is supposed to be protected from creditors under provincial insurance law. Being the case, Veterans Affairs has no right to take your insurance into account to reduce the income replacement benefit because it would violate provincial insurance law. Now, the kicker here is that they didn't put in the Veterans Wellbeing Act regulations. They didn't name the Service Income Support Insurance Plan as a named clawback. So basically, if you get medical release and you're getting SISIP and then they top you up at Veterans Affairs, then they only pay the difference between the two. They don't have any legal basis for it. If they had a legal basis for it, they might be justified. But first of all, insurance is property. Property is the provincial sphere of responsibility under Section 9213 of the Constitution Act. So the federal government can't make laws that intrude upon the provincial jurisdictions. So I know they meant to do it. They put it into the Canada Gazette in 2006. They said that the idea of the earnings loss benefit is to pay this and top up the national defense earnings loss benefit when applicable. So basically, they set both up at 75%. And because they had a program arrangement that said that SISIP was the first payer in the case of medical release, that relieved Veterans Affairs of paying anything between 2006 and 16. After 10 years, they changed the rate of the earnings loss benefit and made it 90% of salary instead of 75% of salary, and then Veterans Affairs had to make a payment. But the way it's supposed to happen is you're supposed to get your non-indemnity and contributory SISIP long-term disability insurance because you bought it in contract. And then you get your payment for your injury on duty from Veterans Affairs, and both of them go together and combine. It's not a clawback of one or the other. You're supposed to get, just like the Dennis Manouche class action, you're supposed to get both. That's the way the system is supposed to be. Now, they don't seem to understand that the common law should matter. Like all of these things that I've been saying, you get both. It goes back to 1875, British case called Bradburn versus Great West Railway. A policeman had a 31-pound insurance policy, got involved in an accident on a railway, was part of this lawsuit against the railway. The railway argued that there was no need to compensate this police officer because it had an insurance policy, and the insurance policy paid him and he was compensated for his injury. And they said, no, he wasn't compensated. He got a non-indemnity payment, and it was due to the contract he signed. A lawsuit's damages is due to the event that causes injury. So because there's a fault-based system that says you owe damages, you owe compensation to someone that you hurt, you can't take the person's insurance into account and save money after you put a person in a wheelchair. Where's the justice there? It's crazy that this whole thing is coming up, that people don't want to pay, so they come up with all kinds of trivial, outlandish, novel ideas, when they should just pay up because they could have avoided paying if they hadn't caused the injury in the first place. That's called exercising due diligence. If you avoid, if you make sure that the accident don't happen, you don't have to pay damages, right? I'm going to shut up after this point. Dennis Menuza's class action. That wasn't income they were paid. They were paid damages in contract. And that was paid to settle the lawsuit. It wasn't paid as service for services rendered, so there shouldn't have been any tax on a payment that was a lawsuit settlement. The reference is Jennings, Supreme Court of Canada, 1969, Income Tax Bulletin 365R2. There are no taxes on a payment of capital. You can't say we're going to want to charge income tax on it because capital and income are different things. Capital is property. Income is new money. Okay? So if you want to charge some kind of tax on a payment of damages, you'd have to go back and look at the principles of the Income Tax Act. It is supposed to tax an increase in your assets, your wealth. If you don't have any money and you go to work for an employer, you exchange your time for money and you had an increase in your wealth. So you had to pay taxes according to the policy behind the Income Tax Act. Now, if you get hurt and someone pays you money to replace your loss, you didn't have an increase in your wealth because you're not allowed to realize a profit under the legal compensation principle. You're only allowed to get paid back up to 100% of your loss and not 1 red cent more. So under the principle of compensation and tort, you can never achieve a profit. So therefore, you can't have to pay taxes on a payment of someone making it as a debt repayment. They're paying you money back to replace the injury they caused you in money terms. They can't do anything else. Listen, that's probably long enough. And I hope that some of the stuff today, I felt I was rambling a bit, going off on different topics. Now I try to corral it, get it back in, but hopefully, I won't be too disjointed, because I'm hoping to get all this stuff fixed one of these days. Okay, I'm not doing this for nothing. I'm not a narcissist doing this just to get attention for the 1 or 2 people that watch this broadcast. I'm hoping something will stick one of these days and someone will say, oh my God, this has to change. How can this continue the way it is doing? They're doing it now. They shouldn't be allowed to get away with it. Thanks for watching. I'll see you next week.